Welcome to the final lesson of the Introduction to American Law course. This is all about searches and seizures. This is something you've probably heard about throughout your education, so let's dive right in. You know that searches and seizures and the Fourth Amendment go hand in hand. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized." Within this amendment, there are really a couple main pieces that people tend to focus on and that our legal system tends to have questioned. So the first half of this really talks about protection against unreasonable searches and seizures. The word that comes into question here is unreasonable. What is a reasonable search? What is an unreasonable search? This is a major question in the legal system today. The next kind of part of this amendment is the idea that warrants cannot be issued except for upon probable cause. The debate concerning this concerns what is probable cause, what allows the police in order to issue a warrant to search something. Then this amendment ends by talking about when police issue a warrant, they need to describe what are they going to search, what are the things or people they're going to take. So when we begin to talk about searches and seizures, we need to understand what exactly a search is. And a search is defined as a violation of a justified expectation of privacy. What this means is whatever you expect to be private should essentially be kept private. So therefore, a search violates this expectation of privacy. However, it doesn't just concern you personally, because the legal system needs to have broader definitions that don't change subjective to each individual person's beliefs. So they develop this kind of broader idea of the expectation of privacy. So, for instance, most people might think that their trash they put on the side of the road isn't something that people should be digging through. They would be confident in expecting their trash to be kept private because they don't expect people to just, search for their trash cans. However, in some states, in many states, in fact, then courts have determined that putting trash in a trash can on the side of the road is not a justified expectation of privacy. People do not have an expectation of privacy when putting their trash on the side of the road. In many states, this is the case, so police don't need a warrant in order to search somebody's trash can. However, in other states, a fewer number of states, then courts have determined that yes, having your trash on the side of the road is a justified expectation of privacy. The next piece of the amendment concerns warrants, and this is basically, uh, y'all have heard about warrants. In order for the police to search something, then they need to secure a warrant. However, there are certain ways that police can get away with not getting warrants and still getting information, and this is the same way that us private citizens can get information if we just ask someone for it. So the police usually have a little more sway because people respect the police more so than an average person. But for instance, if the police want phone records from a company, then they can get it without a warrant if they just ask the company and the company provides it to them. A lot of companies support the police, and a lot of companies don't necessarily turn over that information easily to police. So Police can also get information from these companies if they get a warrant, but something to be aware of is that they do not need a warrant in order to obtain phone records if the companies willingly give it to them. Another idea concerning searches is the plain view search, and this falls under the category of a reasonable search. Remember, the Fourth Amendment protects against unreasonable searches and seizures. However, a plain view search is considered reasonable. What a plain view search is, for instance, say you're this man on the left. You get pulled over by the police, and the police smells marijuana on you or in your vehicle. If the police smells marijuana in a motor vehicle, then he has the right to conduct a plain view search because he smells an illicit substance in a motor vehicle. It's illegal to drive while high, and it's also illegal to have marijuana if you don't have a medical marijuana use card or something similar, depending on what state you're in. So, because the police officer comes essentially face to face with someone who's violating the law, then he can conduct a search without a warrant on said person who's violating the law. So, this would allow the police to ask you to pop your trunk if this were you, and he could look through whatever's in your trunk in order to search for evidence. Another idea to kind of understand this is, imagine if the police obtain a search warrant for one room in a house, but when they walk into a house, then just simply walking through the building, they see uh, automatic weapons laying on a table in another room, just out in plain view. This is where the kind of idea of the plain view search comes from, because if they see something in plain view, then they have the right to search the area and seize objects that are illicit and that this person shouldn't have. In these cases, it would really make no sense to require police officers to leave the premises with illegal substances and evidence of crimes and then obtain a warrant in order to come back to the same premises in order to seize such objects that may or may not be outlined in the initial search warrant. Just a little cartoon for your liking. So there are all these kind of ideas which outline what's a reasonable search. Police need to get a search warrant in what kind of situations. So let's talk about what happens if the police don't follow the Fourth Amendment, if they violate it. This brings us to the idea of exclusionary rule. What exclusionary rule is, it applies to more than the Fourth Amendment, but it certainly applies to the Fourth Amendment, is if the police obtain evidence illegally, then they cannot use that evidence in court. So, for instance, if the police break into your house without a search warrant, without probable cause, and they find evidence of a crime, then they cannot use that evidence against you in court because they obtained it illegally. This is a big protection against abuse of police power because uh, without it, police could just violate defendants' rights in order to get convictions and in order to obtain any evidence or lack thereof that they might think exists. Another more specific doctrine to the Fourth Amendment is the fruit of the poisonous tree doctrine. What this one says is basically evidence obtained in an illegal search cannot be admitted into evidence, or illegal searches in and of themselves cannot be admitted into evidence. So, for instance, let's say that the police break into your car and conduct an illegal search, and they find illicit substances in your car. Well, according to the exclusionary rule, if they find evidence in an illegal search, then they can't use it in court. But what they could try to do is they conduct this illegal search and then they leave and come back with a search warrant and conduct the search again because they know that illicit substances are present. What the fruit of the poisonous tree doctrine says is that they can't use that initial search that would be illegal as evidence to obtain a search warrant for the second one. So essentially what this means is if they conducted an illegal search on your car and found illicit substances, the only way that they could use that evidence in court is if they exited the premises and then, for a reason unrelated to their first search, they were able to search your car again. So, for instance, if they pulled you over later again for speeding and then uh, you had alcohol in the driver's seat, then they could search your car again. This is the idea of searches and seizures. The Fourth Amendment protects against those which are unreasonable. However, there are certain situations that are more reasonable than others, and if the police violate the Fourth Amendment, they can't use that evidence that they obtain in the court of law.